This is Michelle here with Moving Forward Real Estate, and we're going to be going over the exclusive right to sell listing agreement. And you all, I'm out here outside today in my backyard because I thought it was so beautiful out here. So if you hear riding lawnmowers and birds chirping and possibly my dogs, this is why, because I'm wanting to take advantage of this beautiful day. So here we are with this exclusive right to sell listing agreement, and this is the agreement that you're going to use when you land that beautiful home to list on the MLS and all the other platforms. Now, this listing agreement is between the seller or sellers and the firm. The listing firm. Now, the individual agent who signs this agreement shall, on behalf of the firm, be primarily responsible for ensuring that the firm's duties hereunder are fulfilled. However, it is understood and agreed that other agents of the firm may be assigned to fulfill such duties if deemed appropriate by the firm. For purposes of this agreement, the term firm, as the context may require, shall be deemed to include the individual agent who signs this agreement and any other agents of the firm. So this is just stating that this contract here, this agreement is with the firm. However, there is a agent working, several agents that work in the firm. So it's going to be mainly that agent's responsibility to fulfill the duties of this contract and the actual transaction. And there's other agents in the firm too that may assist. So this is what it's saying. So we have a note here. Let's try to go over that. If the property was most recently owned by a person who is now deceased, the tax listing or last recorded deed to the property may not accurately identify that party or parties who should be named as seller. In such cases, the deceased owner's will or applicable North Carolina law, if the deceased owner died without a will determine the correct party or parties to sign this agreement. Advice from a North Carolina attorney should be obtained concerning the party or parties prior to completing this agreement. So it just needs, this is just saying that if someone has passed away and there wasn't a will involved, we need to contact an attorney to find out who are the parties that are now that the home has been transferred to in order to be able to sell this home. So this next section is stating if the owner of the property is a corporation, limited liability, trust, other legal entities, etc., etc. We also need to get in contact with an attorney, a North Carolina attorney, to let us know who is going to be assigned as the actual seller. So wherever the seller block is, it's not going to be Mr. and Mrs. Jones. It could be Moving Forward Real Estate. It could be a trustee, so on and so forth. We just need to know if something has happened like that and the party has expired. We need to know who to put in that seller slot, who owns the property now. And a non-owner spouse should be named as seller because he or she will be required to, in most cases, to sign a deed or release certain marital rights in the property. If a married owner has signed and recorded a prenuptial agreement, postnuptial agreement, or a free trader agreement, consult a North Carolina attorney to determine whether the non-owner spouse will be required to sign. So here in North Carolina, you all, it takes one to buy and two to sell. So it's unfortunate in some cases because I have seen it be really, get really ugly. And in most cases, it's fine. It just depends on your relationship with your spouse or your significant other. And so what this is saying is we need to determine once we sell this home, if you purchase this home, again, one to buy, two to sell. You could have purchased this home before you even met your significant other, and now you all are married. You want to sell this property, and it's in your name solely. But because you all are married now, that spouse needs to agree and has to sign as well. So, I don't know if you fully understood that. If you had purchased a property prior to being married, prior to getting married, you now, your partner, your spouse, has to agree to sign this to sell this property if you choose to sell this property. You can't just say, well, I purchased the home, I done paid for it, that was before you, so you shouldn't have the right. Here in North Carolina, it's 1 to buy, 2 to sell, and they do have a right. They own 50% of the property, even though they had nothing to do with purchasing it at all. So just understand that going in, whether you have a prenup or not, it's because of the law here in North Carolina. 1 to buy, 2 to sell. So if you are married and you purchase a home prior to getting married, if you choose to sell that home, prayerfully you all will come together as a unit and agree on it, and it wouldn't be a problem. And y'all both sign and move on and live happily ever after. So let's move on to this next section. In consideration for the firm's services and efforts to find a buyer for the property, the firm is hereby granted the exclusive right to sell the property on the terms and conditions set forth in this agreement. So with that saying again, is that we have sole rights to sell this home. Seller, you're not going out and making other agreements with other realtors. With this exclusive right to sell, this gives our firm the sole right to taking care of your home, listing your home, marketing your home, selling your home, completing this transaction solely. This section says the seller represents that as of the effective date, the seller is not or will not be, if the property is currently listed, a party to a listing agreement with any other real estate firm regarding the property. Seller also represents that seller has received a copy of the Working with Real Estate Agents disclosure and has reviewed it with the firm. So this is saying again what I have stated before already. We are solely responsible for taking care of your home. We have this deal. This is between you and I as a seller. You're not choosing any other person, making any other side deals with any other realtors upon the effective date of this agreement. And then also it's saying that we should have already, as an agent, we already know that when we come into substantial contact with you all as the clients, we need to have went over this brochure with you, Working with Real Estate Agents. And we have a buyer's agent, a listing agent, a sub agent, and a dual agent. So we just needed to explain that to you, go over all the relationship that we have as realtors, and then let you know this is who we are. This is what we're acting as. We're acting as the listing agent to you. And we needed you to just initial. That's not a contract. That's not saying that you hired us or anything like that. This is just something as realtors we need to go over with all of our clients to just let them know moving forward. This is who I will be to you. This is how I represent you. And this is how the other parties, fit in this whole real estate agency. So this section right here, number 1 is term of agreement, and A is term. The term of this agreement term shall begin on its effective date and shall end 11/59 on the expiration date. B, the effective date. The agreement shall become effective, and the seller and firm's respective rights and obligations under this agreement shall commence effective date as follows. So this is what we're going to be checking off here. The effective date shall be the date that this agreement has been signed by both seller and the firm. The property is currently listed for sale exclusively with another real estate firm. The seller represents that the current listing agreement expires on XYZ date, and the effective date of the agreement shall commence immediately upon the expiration of the current listing agreement. So this is pretty much saying that you have been working with a realtor, and for whatever reason maybe the home haven't sold, or there's a little bit of bad blood between you and the realtor, and y'all have come to agreement to basically dissolve this agreement between the two of y'all. More so is the expiration date has expired, and it was supposed to be up at the end of the month, and you all did a 3-month contract together and it has expired. So now we're going to pick it up from that point. So this is saying that you already have been with them prior. This is not like before, like you were working with them and were trying to work with us. This is something that you've already been working with this agent, and the term is over and you just wanting to go with another realtor. So we're gonna check this box off saying that you are, and then fill in here when that contract or agreement is going to expire. C, the expiration date. This agreement shall terminate at 11:59, and we're going to put on here how long we're going to be working with you. So it could be 3 months, it could be 6 months, whatever we determine is going to be the term of this agreement. This is what we're going to pick, and this is where we're going to place that date, and it's going to expire 11:59 on that date. Number 2, this is the property. So we're going to be placing your address in here, because this is the address, your home address. This is the property that we're selling, so this is what goes here. And let's look at this little note here. Okay, governmental authority over taxes, zoning, school districts, utilities, and mail delivery may differ from the address shown. So this is just stating that this address here, let's just call it 123 Main Street. The next page, when we get to it in the agreement, we're gonna talk about a legal description that's gonna differ from this. The traditional mail address is what you use when you are sending people mail, or they're sending you mail, correspondence, anywhere through the mail delivery service. This is the address that we're going to use that is going to differ from this legal description. And now we're here at the bottom of the page, and of course, as you all know, we need initials at the bottom of each page stating that you understand what has been previously stated before these initials. So that's all that is saying. You understand. Let's start here on page 2, and this is the legal description that I'm talking about, and we will obtain that. We can, as realtors, we have a slot on in the MLS called the Real List, so we can get it from the county tax records to fill in all this information: the legal description, the lot and unit, the block section, the subdivision that your home is located in. We're looking for the plat book and the pages, the PIN, all that to identify. This is the legal description to identify your property, 123 Main Street. So it will differ in the way it looks, but it's still one and the same. That legal description means that that is your property, and we want those two to coincide so we know that we are selling the correct property and the buyers will be purchasing the correct property, because those two things are going to match. Okay, this note is stating the following: paragraph 3 and 4 are part of the offer to purchase and contract form 2T, a form which is commonly used to put residential real estate under contract in North Carolina. To minimize the potential for disputes with a buyer, it is highly recommended that sellers and the individual agent who signs this agreement discusses in detail and describes in writing in paragraph 3 and 4 what items the seller is willing to convey as a part of any sale of the property, what items the seller would like to exclude from any sale, and what items are located on the property that the seller may not own. So all this is saying is that we need to, when it comes down to we finding a buyer, that we need to be specific as to what does convey, what doesn't convey, and what items is a lease that you lease. You don't own it, so you can't sell something that you don't own. Here we are at section 3, and that's the fixtures and exclusion. So it's just kind of the pairing going along with what items does and does not convey. Let's look at this warning. The party should not assume that an item will or will not be included in the sale based on an oral or written statement or understanding that is not a part of a sale contract. Buyers and sellers should be specific when negotiating what items will be included in or excluded from this sale. Again, it's repeating itself, but we're repeating ourselves for a reason, because we got to be specific. And there's a lot of times, more than not, that the buyers will go to a home, look at certain things. I mean, the sellers has cleared out the home, but they've left certain items. And that doesn't mean that they're selling those items. It just means that they're going to come back and get them because we have not listed it. You all didn't tell us as your realtor that the washer and dryer is conveying, or that riding lawnmower is conveying. So we don't want to misrepresent or make the buyers feel as though this is a part of the home. So we want to make sure that we list everything in the contract, and then when we list it even online, that we're putting down those exclusions, because even though it's in the house and they came in and we showed and viewed the house, that exclusion says this is what is conveying, but the basketball goal, the washer and dryer, the riding lawnmower does not convey. We need to have that in there. So that's what it's saying. So let's go down here to A. Fixtures are included in purchase price. All existing fixtures are included in the sale as a part of the purchase price, free of liens unless excluded in paragraph subparagraph D or C. Again, it is saying that all the fixtures, everything that comes with the home, we kind of say like if the home turns upside down, everything that doesn't fall, but then they have added some things to that too, like remote controls and items like that has become a fixture because it's attached to whatever the Vivint system and things like that. So we just need to get specific a little bit more than what we have, because this is why these contracts are getting longer and longer and longer, because stuff is coming up. So we need to get a little bit more detail as to, okay, what do you mean by that? Okay, what is that? But what if that happens? So this is why they're getting a little bit longer, so we can be a little bit more clear, so there's no confusion with the seller and the buyer. On B, we're discussing the specified items. And buyer and seller agree that the following items, if present on the property on the date of the offer, shall be included in the sale as a part of this purchase price, free of liens, unless excluded in subparagraph D or C below. All items listed below included both traditional and smart versions and any exclusively dedicated related equipment and or remote control devices. So here again, it's just saying to you what these items are. So we're breaking it down. What do you mean when you say fixtures? Like I said, we used to say, okay, well, anything that falls when we turn the house upside down, that is the things that doesn't fall, that's the fixtures. Well, we have changed that up and added to the list. So this is the list that we will go through with you as the seller, to let you know these items that they do convey. And let's just finish off here today with C, and unpairing, deleting data from devices. So that's pretty self-explanatory. Anything that is conveying, if it's a remote control that you had your special way of pairing it, and it has information in there the way that you like things, or your Vivint system, it has your information on there, your codes on there, all of that stuff. Any of the virtual assistant hubs, intelligent mobile devices, so on and so forth, we want you to unpair that and delete all personal data. So we're going to need your initials here at the bottom of page 2.